Namaste and welcome to our web series called The Indian Lawyer Legal Fundamentals. I am Sushila Ram Verma, the Chief Consultant and co-founder of the Indian Lawyer and Allied Services. Today's episode deals with frustration of contracts. In the recent times, the pandemic of coronavirus has brought the world to a complete halt. Contracts at all levels are virtually impossible to perform due to this force majeure condition. The Indian Lawyer and Allied Services is a multi-city commercial and business boutique law firm that has the necessary experience and knowledge to deal with such domestic and cross-border contracts that have been affected by the pandemic. It is our endeavor to share legal knowledge through this presentation to enable such contracting parties to understand the significance of the breach of contract terms. The Indian Lawyer and Allied Services is releasing a series of presentations on different aspects of the contract law on YouTube called TIL Legal Fundamentals. The legal information shared in the video is general in nature and has been prepared for public viewing, awareness and knowledge only. It is not to be taken as legal advice. What is frustration of contract? Frustration of a contract means the occurrence of intervening events that are so fundamental as to be regarded by the law as striking at the root of the contract. It is beyond what was contemplated by the parties at the time of entering into the contract. The terms impossibility and frustration are often used interchangeably. It is said that the changed circumstances make the performance of the contract impossible. As a result, the parties are absolved from further performance of the contract as they are unable to perform an impossible act. Further, if the performance becomes impossible as a result of any external force, supervening or force majeure event that is beyond the control of the parties, then the promisor is usually excused from the performance of the contract. The expression force majeure is a French version of the Latin expression vis major. Force majeure means an act of God or an irresistible force which is unforeseen, unstoppable, and beyond a person's control. It renders the performance of contract impossible. For instance, force majeure events would include earthquakes, tsunami, eruptions, the fire, war, radioactive contamination, outbreak of disease, epidemics, pandemic, terrorist activities, interference by official authorities, which includes business acquisition by the states, government sanctions, and embargoes. Generally, force majeure clauses are added in all major contracts, such as construction contracts, loan commitment documents, trade-related agreements, shipping documents, etc. It is added with the intention to relieve a contracting party from performance of contractual obligations. It endeavors to save the party from the consequences of non-performance or delay in performance due to the occurrence of a force majeure event, which is beyond its control. The doctrine of frustration of contracts is covered by Section 56 of the Indian Contract Act 1872. Section 56 states, an agreement to do an act impossible in itself is void. Under this section, if the act agreed to be done is inherently impossible of execution because of supervening events, physical or legal, which no party could have foreseen, then in such cases, frustration of contract occurs and the contracting party is excused from performance of the contract. Conditions for invoking doctrine of frustration. The doctrine of frustration is a part of the law of discharge of contract by reason of supervening impossibility or illegality of the act agreed to be done. To invoke the aid of frustration, the party who wants to establish that the contract has become frustrated has to establish the following conditions. That there is a valid contract between the parties, that the contract is yet to be performed and has become unlawful or impossible to perform, that the impossibility is not on account of some event which the promiser could prevent or anticipate, that the impossibility is not self-induced by the promiser or due to his negligence, that the impossibility to perform is caused by an event which is beyond the control of both the parties. Hence, where it is alleged that the contract has been frustrated, the court will examine whether the supervening event has vitally affected the contract, making it impossible to perform. Conditions for invoking force majeure. Not feasible. Force majeure events should render a party impossible to perform and execute a contract. Unpredictable. The events in question should be beyond control, foresight, and anticipation of the parties. External force. The party should have no role in the occurrence of the force majeure event. Further, the event should have taken place without the fault or negligence of the affected parties. In such a case, the party is absolved of its liability for any damages or expenses arising out of the force majeure event. Certain cases are not covered by the doctrine of frustration. These are commercial hardship or difficulty, self-induced frustration, act of third party, failure of one of the objects, executed or performed contracts. Frustration of a contract has the following effect. The contract automatically dissolves, irrespective of the choice or election of either party. However, the party who has received any benefit out of such contract must compensate or restore the other party of such benefit. The Supreme Court of India has upheld frustration of contracts in several cases. Some of the leading cases on the point are as follows. Satyabrata Ghosh versus Mugdi Ram. In this, a four-judge bench of the Apex Court held, the relief is given by the court on the ground of subsequent impossibility when it finds out that the whole purpose or basis of contract was frustrated by the intrusion or occurrence of an unexpected event or change of circumstances, which are beyond what was contemplated by the parties at the time when they entered into the agreement. When such an event or change of circumstances occur, which is so fundamental as to be regarded by the law as striking at the root of the contract, the court can pronounce the contract to be frustrated. In a 2014 case, Sri Ram Builders, the bench of the Apex Court referred to the judgment of Bhutalinga Agencies, the 1969 landmark judgment, and held that the doctrine of frustration of contract is really an aspect or part of the law of discharge, and it is within the purview of Section 56 of the Contract Act. It should be noticed that Section 56 lays down a rule of positive law and does not leave the matter to be determined according to the intention of the parties. The provisions of Section 56 of the Contract Act cannot apply to a case of self-induced frustration. In other words, the the doctrine of frustration of contract cannot apply where the event which is alleged to have frustrated the contract arises from the act or election of a party. In Energy Watchdog vs. Central Electric Regulatory Commission 2017 Supreme Court, the Gujarat Urja Vikas Nigam issued public notice and invited bids for supply of power. Later, Haryana Utilities also initiated a similar bidding process. Adani Enterprises was selected as the successful bidder for 1000 megawatt of power by GUVNL, and a PPA was signed between Adani and GUVNL. Haryana Utilities also selected Adani Enterprises, and another separate power purchase agreement was signed. Thereafter, owing to certain change in laws in Indonesia, there was an increase in export price of coal. As a result, Adani Enterprise filed a petition before the Central Electricity Regulatory Commission seeking relief to discharge from performance of the contract. CERC refused to do so. Adani Enterprises went to the Supreme Court. The Supreme Court observed that as per the said power purchase agreement, change in cost of fuel cannot be considered as a force majeure event. It further held mere rise in price rendering the contract more expensive to perform will not constitute a hindrance. Thus, the apex court held that neither was the fundamental basis of contract dislodged, nor was any frustrating event except for the price of coal pointed out. Alternative modes of performance were available even though at a higher price. Therefore, this does not lead to the contract being frustrated. In the recent times, the COVID-19 pandemic, which is a force majeure, has resulted in impossibility to perform contracts in many cases. Parties who have not been able to perform due to the pandemic can plead frustration of the contract. Conversely, the aggrieved party can claim compensation. For any further queries, please contact us at any of the following